Dear friends, in this course on social welfare and social legislation, we would be now looking at the issue of human rights. As per the theory of justice, according to the noted legal scholar Rawls, justice is a virtue of society, and one of the main objectives of justice is to secure human rights to all. So, what are human rights? Simply defined, human rights are those rights to which every person is entitled just by virtue of that person being a human being. Thus, they are universal entitlements available to all persons without regard to any personal attributes they may or may not possess. Let us now look at a brief history of human rights. In the Western tradition, we may say that though there were some developments since the time of Magna Carta, which was 1215 AD, the concept of human rights is very much a product of the age of enlightenment in the 18th century. Indeed, the term human rights was used for the first time by Declaration des droits de l'homme et du citoyen, linked to the concept elaborated by Jean-Jacques Rousseau, who said that the sovereign derived his powers and the citizens derived their rights from a social contract. Human rights were seen as something that was the preserve of the state, and interventions, international monitoring or regulation was uncommon. The International Labour Organization came closest to any form of international codification of rights, but these rights were more social rights than human rights. It was only after the Second World War, with the formation of the United Nations organization, that there was some international agreement that human rights are an international issue and that countries should take steps collectively to protect human rights. In pursuance of this line of thought, in 1948, the Universal Declaration of Human Rights, the UDHR, was adopted by the member countries of the United Nations. The rights named in the UDHR have gained wide acceptance as human rights in most of the world, and any set of human rights that are guaranteed by various constitutions around the world are based on the Universal Declaration of Human Rights. Some of these rights have been given an elevated status and are called inalienable rights. The human rights are usually those which are seen as essential to the security and dignity of the individual, and they seek to protect some rights. Though the Constitution of India doesn't mention the human rights by name, most of the human rights, especially the important ones, have been recognized as fundamental rights under the Constitution of India. We may see here some correlation between the human rights as per UDHR and fundamental rights as per the Constitution of India. Article 1 of UDHR declares that all humans are born free, equal in dignity and rights. Article 14 gives under the Indian Constitution, which is similar to Article 1 of UDHR, grants right to equality, and Article 15 grants the right to non-discrimination by the state on grounds only of religion, race, caste, sex, or place of birth. We also find Article 16 stating that there must be non-discrimination in matters of public employment. And in Article 2 of the UDHR, we find that everyone is entitled to all the rights and freedoms set forth in this declaration without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. Article 7 of the UDHR states that all are equal before the law and all have equal protection of the law. Thus, we find a close correlation between these provisions of UDHR and the Indian Constitution. Similar correlation can be seen in the case of Article 3, which says the right to life, liberty and security of a person is a right under the UDHR. Under the Indian Constitution, Article 21 similarly declares that no person shall be deprived of his life or personal liberty except under procedure established by law. Article 4 of the UDHR prohibits slavery. Article 23 of the Indian Constitution prohibits begar and forced labor. Article 8 of the UDHR states that there is a right to effective remedy, and Article 32 of the Constitution grants a right to constitutional remedy. Article 9 of the UDHR says that no one shall be subject to arbitrary arrest, detention or exile. The Indian Constitution, through Article 22, grants a fundamental right of protection against arrest and detention in certain cases. Article 13 of the UDHR grants a freedom of movement, and Article 19(1)(d) of the Constitution also grants the same. Article 18 grants the freedom of thought, conscience and religion, and Article 25 grants a freedom of religion under the Constitution of India. Article 26 grants a right to education, and Article 21A of the Constitution of India grants a right to freedom and compulsory education. Thus, we can see that all the important human rights as per the UDHR have been guaranteed in India by the fundamental rights under Chapter 3 of the Constitution of India. At a global level, the UDHR is now supported by several international conventions, such as the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. Let us now look at the nature of obligations which are imposed through human rights. Human rights, by nature, are obligations upon states and not upon individuals. Though one might say that even an individual could deprive another of his human rights, it is the duty of the state to stop and prevent any human rights violation. For example, though it is very possible that a private person X might be enslaving Y or exploiting him, the remedy against this human right violation will lie only through the state. That is, it is the duty of the government to prevent such violation. Let us now look at the scheme of classification of human rights. One of the bases of classification of human rights is between classic and social rights. Though the difference between the two isn't strict, there are some broad lines that may be drawn. Classic human rights are usually those which require non-intervention by the state and rather require the state to refrain from indulging in certain types of behavior. They are also called negative obligations. Social rights usually require some sort of action by the state and are also known as positive obligations. There is also a difference in nature of the outcome expected from actions towards securing these rights. The benchmark in the case of securing the classic rights is an obligation of outcome. In the case of social rights, it is usually a duty to provide the means or an obligation of conduct. However, this distinction is being blurred lately as there are several classic human rights that require considerable effort by the state, and on the other hand, social rights often contain aspects which are best achieved if the state leaves the people to themselves. Another classification is between civil and political rights on one hand and social, economic and cultural rights on the other. This is a very contentious distinction as it seeks to put in one group civil and political rights such as the right to life, liberty, security of the person, freedom from arbitrary arrest, torture, physical violence, detention, exile, slavery, freedom of expression, freedom of association, freedom of assembly, etc. This group is in contradistinction to another group of rights such as right to property, right to work, right to fair wage, right to reasonable working hours, right to participate freely in the cultural life of a community, right to participate in the scientific advancement, etc. One difference that has been claimed between the two groups of rights is that while the civil and political rights are claimed in certain terms and are quite clear, the socio-economic rights are framed in a vague manner. The dichotomy of negative obligations for civil and political rights and positive obligations for socio-economic rights is also brought in. It is further claimed that for this reason the former are justiciable whereas the latter are not. This would find some reflection in the Indian Constitution before the 1980s. Then one could say by and large that the civil and political rights are contained in the chapter on fundamental rights in the Constitution, which is justiciable, whereas the socio-economic rights have been included in the chapter on directive principles of state policy, which are not justiciable. While even then we could see anomalies which did not conform to this distinction, such as Article 29, which provides for protection of cultural rights of minorities. After the 1980s, the decisions of the Supreme Court and the High Courts have brought several new rights within the scope of fundamental rights. Many of these rights, such as the right to livelihood laid down by Sodan Singh versus New Delhi Municipal Corporation, would traditionally have been in the realm of socio-economic rights. The very fact that the courts are deciding such cases show that these rights too are now considered justiciable in India. Another way of looking at human rights is by dividing them into individual and collective rights. The basis of this division here is how these rights may be enforced. Individual rights are those that may be exercised individually, while collective rights are available to the individual. The exercise of these rights is usually as a collective. For example, the right to associate freely is a right that is available to every individual. However, it can be exercised only collectively. This has been an era of international enforcement of human rights. Some of the universal human rights conventions are the Convention on the Prevention and Punishment of the Crime of Genocide, ILO 98 concerning the right to organize and to bargain collectively, the Convention against torture and other cruel, inhuman or degrading treatment or punishment, the Convention relating to the status of refugees, the Convention on the Rights of the Child, ILO 169 concerning indigenous and tribal peoples in independent countries, the International Convention on the Protection of the Rights of all migrant workers and members of their families, ILO 111 concerning discrimination in respect of employment and occupation, the UNESCO Convention against Discrimination in Education, the International Convention on the Elimination of all forms of racial discrimination, the International Convention on the Suppression and Punishment of the Crime of Apartheid, the Convention on the Elimination of all forms of discrimination against women. Apart from these conventions and treaties which are applicable to member countries around the world, there are some conventions which are taken up at a regional level. These also often contemplate regional organizations for the enforcement of human rights. The examples may be the following: the American Convention on Human Rights, the Convention to Prevent and Punish Torture, which is an inter-American convention, the Convention on Forced Disappearances of Persons, the African Charter on Human and People's Rights, the Protocol on Rights of Women in Africa, the European Convention. After having looked in detail at the instruments concerning human rights, we should now look at the system of enforcement of human rights. The system of enforcement of human rights on an international scale is not as strong as it is within respective countries. Enforcement happens only through tabling of reports, monitoring, etc. It is very rarely that individual cases are taken up at an international level worldwide or at some regional organization. It is only in cases of egregious violations or large-scale offences does the international community intervene. However, the national systems are worth taking note as they are truly capable of safeguarding human rights at even an individual level. In India, we may see that the foremost system for protection of human rights is through the courts which protect the fundamental rights guaranteed under the Constitution. The courts have come a long way from the era where a literal reading was given to fundamental rights, and consequently, the variety of human rights protected and the scope of this protection was limited. One case which at once shows the character and limitation of this approach is that of A.K. Gopalan versus State of Madras. Here, the court held that where Article 21 of the Constitution of India seeks to protect life and liberty and provides that they can be abridged only according to procedure established by law, it can only be interpreted as having some statutory backing, and that the court would not go into the question of whether the statute itself was fair or not. However, the position changed more than 2 decades later in the case of Maneka Gandhi versus Union of India, where the court read the same provision in a broad manner and said that it is not enough if the provision is made under law, but it must also follow some rules of natural justice. The public interest litigation era has greatly magnified the scope of this form of remedy. Not only have the courts been proactive in protecting human rights, all that have already been recognized by the Constitution, but the court has also gone ahead and read more rights into the chapter on fundamental rights. While these attempts to bring in more discretion while accepting PILs, the courts have today established themselves as upholders of human rights through decisions in cases like Rudul Shah, Bihar under trials case, etc., where the court picked out cases of human rights violations and directed the concerned authorities to remedy the same. However, one failing of pinning all hopes on the judicial system for the protection of human rights is that by its very nature, the judicial system is structured so that only those who recognize their problem and have the wherewithal to fight for their rights will ever get a hearing. Further, in a general court of law, the justice delivered might not be of the same sensitivity to human rights as that in an institution that is dedicated for the purpose of protection of human rights. To overcome these flaws and to bring the legal system in India in accordance with the obligations under international conventions, India had to go in for a statutory system of protection, in addition to the constitutional protection available. Thus, the Protection of Human Rights Act was enacted in 1993. This act provided for the setting up of the National Human Rights Commission and the State Human Rights Commissions. The Human Rights Commissions are apex bodies which are to be headed by former judges. The main functions of the National Human Rights Commissions include inquiring into violations of human rights. This inquiry might be on a complaint or on its own, which is called suo motu. They may visit jails or other institutions where persons are held and carry out inspections. They may review the safeguard of human rights under the Constitution, review the conditions that are leading to violation of human rights. They may undertake and promote research in the field of human rights. They may study treaties and international instruments for their effective implementation. They may spread human rights literacy. They may encourage NGOs working for the purpose of human rights. To carry out these functions, the National Human Rights Commission will have the power of a civil court under the Civil Procedure Code. It also has the power to summon any person to furnish information required by it. It has the permission to authorize an officer to enter any building to conduct inquiries. The Protection of Human Rights Act also stipulates the procedure to be followed. The Act also provides for human rights commissions at the state level which have similar functions and powers, albeit at the state level. The Act also provides for human rights courts that may be set up. India is a diverse land occupied by a civilization with a complicated history. This also means that the diversity of human rights violations that obtain here are without parallel in the world. In addition to the traditional human rights protection legislation, India has some legislation that may be termed to be protecting human rights of certain specific groups. Here we are talking about the Sati Prevention Act, the Protection of Civil Rights Act, Prevention of Atrocities Act, which combat some social evils which are peculiar to India. One common refrain amongst most observers of the human rights situation in India is that while the legal system is in place to tackle the human rights problems, the results on the ground are not seen to be that effective. That perhaps means that there is a need for a relook at our strategy in the protection of human rights.